With Sean Diddy Combs being denied bail yet again, what's next for him? Can he try for a fourth time? I'm going to be breaking it down with former federal prosecutor Nima Rahmani. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. What's next for Sean Combs? That's the question. For the guy who was denied bail for a third time and will conceivably remain locked up at the Metropolitan Detention Center pending his May 2025 trial on federal sex trafficking and racketeering and prostitution charges, the question we're now asking is, can he ever get out of the MDC, the Metropolitan Detention Center? Does he have another chance at bail? I'm going to quickly set the stage for you to tell you where we're at. So, as we reported to you here on Sidebar, Combs was denied bail by the current judge overseeing this case, Judge Arun Subramanian. Did it right on the eve of Thanksgiving, Wednesday night. And that is a big blow to the embattled rapper and producer who's facing these federal charges that could conceivably send him to prison for the rest of his life. Now, the judge, in his order, was moved by several factors. Judge Subramanian wrote on page 1 of the order, "The court finds that the government has shown by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of the community." Now, first, aside from the allegations in the indictment that detail an alleged scheme going on for years where Combs allegedly abused, threatened, coerced women to fulfill his sexual desires, that he operated a criminal enterprise that was engaged in all sorts of illicit activity, putting that to the side, besides those allegations, Subramanian also cited the 2016 videotape of Sean Combs purportedly beating his ex-girlfriend, Cassandra Ventura, that was published by CNN several months ago, that, coupled with all the allegations in the indictment, is evidence of his violence. It's his propensity to violence, his dangerousness. Dangerousness is an important factor in a bail analysis. Second, Subramanian ruled that Combs presents a serious risk of witness tampering, obstruction, like improperly contacting a grand jury witness and trying to cover it up. Third, Subramanian says that Combs violated the Bureau of Prisons regulations in the MDC to obscure his communications with third parties, whether that be paying other inmates to use their phone access code numbers to make calls to people who were not approved on his contact list, or instructing family members and lawyers to add people to three-way calls. And while the prosecution said, this is clearly an attempt to improperly contact witnesses of the case or influence a jury pool, Subramanian, in his order, said, I'm not even going to make a determination on the content of those communications. It's just the fact that he violated BOP rules that matters. He broke the rules while in the MDC, while he was seeking bail, and when he knew the government had already alleged he was reaching out to witnesses and engaging in obstruction, and yet he does this? Subramanian says, and despite all that, he does this from behind bars? What makes you think he can be trusted on the outside? 4, and this was really interesting, Subramanian took issue with what he perceived to be Combs' lawyers, saying that they misrepresented to the court whether Sean Combs' legal pads in his jail unit were actually labeled legal or not. And that, again, was with respect to a separate inquiry on whether his rights were violated when photos were taken of those legal pads. That's a separate issue. But the idea is, can I even trust your lawyers, Mr. Combs? And by the way, Subramanian also cited the fact that Sean Combs' lawyers told a previous judge, hey, court, Combs didn't reach out to a grand jury witness in this case. But guess what? He allegedly did. So it goes back to this idea of, how can I even trust the lawyers to make sure that Sean Combs will do what he needs to do on the outside? Number 5, let's talk about Sean Combs' bail package. And Subramanian seemed to be entertaining the idea of pretrial release, because at a prior hearing, Combs' lawyers suggested that they would have this apartment ready in New York City, that there would be 3 private security members who monitor Sean Combs, that he would have no access to phone or internet, that he would have a pre-approved visitor list, there would be a $50 million bond. Subramanian wrote, the court doubts the sufficiency of any conditions that place trust in Combs and individuals in his employ, like a private security detail, to follow those conditions. And here's the final point. Combs is in a different position than Mike Jeffries, the former CEO of Abercrombie, who was recently also arrested and charged with federal sex trafficking crimes in New York. Why? The difference? The issue with Jeffries was less that he was a danger on the outside versus him being a flight risk. He has no criminal history. The allegation stemmed from a decade ago in that case, and he's 80 years old. And there was also no racketeering or RICO allegation like there is with respect to Sean Combs. So with all of that in mind, Judge Subramanian said no to bail. The bail request was denied. But now the question is, can Sean Combs get another shot with Judge Subramanian? Or what will be his likelihood of success in a different court? Because there's currently a pending appeal at the Second Circuit Court of Appeals. So to get into all of this, I want to bring on former federal prosecutor Nima Rahmani, friend of the show. Nima, thanks so much for coming on. First, before we even get into what he can do next, were you surprised by this decision by Judge Subramanian? Because you and I were covering this live when this hearing was happening, and we were floating the idea maybe the judge is entertaining the idea of pretrial release. Were you surprised the judge decided this?
Jesse, thanks for having me on the sidebar. As always, I'm not surprised with the decision. I'm surprised that Judge Subramanian entertained it. He held a 2-hour hearing, which we were covering live, and he issued a 5-page written order. Most other judges, including the 2 previous judges, to consider this issue, summarily denied the bail motion. I think a lot of it stems from Judge Subramanian being a newer judge. This is a Biden appointee. He has a civil background, doesn't have a whole lot of criminal experience aside from being a district judge. So I think someone with more experience would have denied this outright. Maybe he's slow, maybe he's very deliberate. But the fact that he entertained the defense's privilege motion, ordered the prosecution to destroy the 20 some odd pages of documents while he considered the in-camera review, leads me to believe that this is probably going to be Combs's best audience when it comes to this issue. And I don't think he's going to do better on a motion to reconsider the bail issue or on appeal to the Second Circuit Court of Appeals.
First of all, from a legal point of view, I very much appreciated Judge Subramanian's questions because they were pointed questions, tough questions to both the prosecution and the defense. And I have to say, the fact that he was asking, well, where would home confinement be? And he rejected the idea of Florida and says, where else would it be? And then they came up with the idea of an apartment in New York and talked about what that would look like. It was very interesting to me. And I think he wants to be diligent. And he, in his order, he said he reviewed the record not only from that prior hearing, not only the briefs from both the prosecution and the defense, but he also reviewed the transcripts of the prior hearings, because there was a district court judge and a magistrate court judge, as you said, who both denied Sean Combs bail. So this was a 360-degree analysis. What I found really interesting was he didn't even entertain the question of risk of flight. The whole reason he denied Sean Combs bail was because of the dangerousness element, right?
I agree. And the risk of flight was always going to be a tough argument for the government because obviously Combs voluntarily came to New York. He surrendered his passports through his lawyer. He could have fled after the March raids of his Miami and Los Angeles homes, but he didn't. He has access to 2 private jets. I think it was a tougher argument. I know the government made the argument, but clearly the best argument was the dangerousness and the witness tampering. They had much more evidence with respect to those 2 elements.
How much was it with respect to Sean Combs' behavior versus his lawyers? There was a point in the hearing when his lawyer said, you can trust us. If we tell him not to do something, he won't do it. But as I mentioned, he kind of Judge Subramanian took issue with how the defense, their representations to the court, his court and another court, that they might not have been totally transparent about what was going on. Do you think that if this didn't happen, he might have been more receptive to Sean Combs' plea for bail? Why I say that is, let's say Sean Combs was to get completely different lawyers, right? Completely different lawyers. Could that change the analysis?
Potentially, but there was either outright misleading or attorneys who can't control their client. And one very important point in the judge's order was Combs was using PAC numbers and software to mask his phone calls as of recently, as of November 24th, even after the bail hearing. So that's something that the judge cited to saying, hey, you're saying your client is no longer violating BOP rules and the MDC rules with respect to these phones, but he's doing it even after the hearing where you represented that this conduct would stop.
I've spoken to defense attorneys about this, And they said it's not a big deal if he's using other pack numbers. It's not a big deal if he's using three-way call. And by the way, unless I'm wrong, and I don't think I am here, Judge Subramanian said, I'm not going to address the actual content of those communications, whether or not he was engaging in witness tampering or he was even engaging in trying to taint a future jury pool, because he seemed kind of skeptical to that argument about tainting a future jury pool, because that allegation was about Sean Combs is having his family members post about his birthday and he's trying to change public opinion, and there was evidence that he really wanted to influence a potential jury pool. Judge Subramanian didn't, again, unless I'm wrong, didn't even entertain. It was more entertain that idea, and even getting into the content of it. It was he violated the Bureau of Prisons rules. If he's violating those rules, what makes us think that we can be assured he won't violate the rules of his bail? And I've spoken to, so A, correct me if I'm wrong there, but B, I would also say that multiple defense attorneys I've spoken to say everybody breaks those rules. That's not a sufficient enough reason for him to be denied bail.
Well, it's really important in this case because the case is going to come down entirely to that witness testimony, right? There is reportedly some video evidence of the freak off, so it's going to be interesting to see what they show. Obviously, we've talked about the 2016 video of Combs beating Cassie Ventura, but ultimately, the defense in this case is that this conduct was all consensual. So Combs is going to need the witnesses here, the victims, to go sideways at trial. How'd you like that pun? By the way. But so, the government's argument is that Combs is trying to threaten, blackmail, dissuade, even outright bribe witnesses to prevent them from showing up, or if they do show up, to take a very different position than they have in meetings with federal agents and potentially before the grand jury. They show up and they say that all this happened, but it was consensual. That's Combs's defense here, and that's apparently what he's trying to do through these communications. So it's not just, breaking rules, using someone's, this is actually a crime. This is witness tampering. This is obstruction of justice. If I'm prosecuting this case, and we've talked about this before, Jesse, I would supersede to add the sex trafficking of minors if there's obviously evidence of it. But importantly, the obstruction of justice charges, not because I think it's going to add any additional time to the case, but it's going to bring in all sorts of very bad evidence for Combs.
I was going to ask you if you think that, I was actually curious about whether or not if he was actually granted bail, if he was granted pretrial release, I thought prosecutors might hit him with a superseding indictment because they're already presenting evidence to a grand jury and say, okay, we're about to charge him now with more crimes, obstruction, perhaps some other sex trafficking related crimes, or amend the indictment to include these allegations to support the racketeering charge, because the racketeering charge includes a lot of different alleged illicit conduct, and say, we're going to add all of these allegations of obstruction, new charges. That's a way to get him back behind bars and get him, present this argument to the judge again. So, and now I am curious, do you think that it's possible they will hit him with a superseding indictment that will completely foreclose any opportunity he may have for bail?
I think so, and I certainly would. I think those are the two defenses I would anticipate, the witness changing their testimony or the consensual conduct. Again, I don't know what the video shows, but if I'm the government, I try to get out ahead of those two defenses, because really it's the only possible way that you lose this case if, the witnesses go sideways here.
Let me go back to the Second Circuit. So correct me if I'm wrong. He had appealed to the Second Circuit. He actually put that on pause. It was it's called abeyance. Let Second Circuit, I know I'm appealing this bail issue to you. Put it on pause. I want to go to Judge Subramanian. We haven't argued this bail issue in front of him yet. Let's see what happens there. If that's not successful, we're going to go back to the Second Circuit. What is the difference between what Judge Subramanian just decided and what potentially the Second Circuit could decide? Is there any way they would be more sympathetic to Sean Combs' bail arguments and ultimately grant him bail? Talk to us about how that would work.
It's certainly possible, but in these types of cases, appellate judges are really supposed to defer to the discretion of the trial court. They're the ones who hold these types of hearings and they make decisions. Now, obviously, if there's an abuse of that discretion, they can reverse, but that's very uncommon in my experience, where an appellate court will step in and say, you know what, the denial of bail is an abuse. We saw it in the DC circuit with respect to some of the Capitol rioters. So it does happen, but it's not very common. So I would be very surprised if the Second Circuit 3-judge panel steps in, especially when one magistrate judge, now 2 district judge, Carter and Subramanian, and even pretrial services. Let's not forget, they're an arm of the court.
Right.
They come in with their recommendation, and their recommendation the whole time has been detention. So everyone, aside from the defense, has ordered or recommended that Combs be detained. So I'd be surprised if an appellate court disturbs that ruling.
And the circumstances got worse for Sean Combs. The allegations are worse now with these allegations of witness tampering from behind the MDC. That didn't happen yet with respect to Judge Carter and Judge Tarnowski, because they had already decided Sean Combs was a danger to society and a risk and obstructive. And now you have all this new evidence for the prosecution. But what I do think is interesting is what you said with the Second Circuit. They would be reluctant to overturn the trial court's decision. Maybe that's why Judge Subramanian was so meticulous and took his time, so that the defense can't say, oh, he just so easily dismissed our claims. He decided it in one day. No, he took his time. And yes, he waited till the eve of Thanksgiving to announce it, but he basically did a thorough review, and it might be more difficult for the defense to ultimately say that he wasn't fair. But going back to Subramanian, what could be a change of circumstances that that he would review the bail condition, unless, I don't know, Sean Combs' defense attorneys can raise the bail issue every week if they want. What would be a change of circumstances that he would actually revisit this issue and maybe have a different point of view?
I think it's very unlikely. We're about 6 months away from trial, and something would have to dramatically change in terms of counts being dropped, witnesses, again, not supporting the allegations in the indictment. And really, the only one that's identified so far as V1 is Cassie Ventura. So I don't know how a change in the evidence would support. And like you said, it just keeps getting worse for Combs. He's his worst enemy. And we say this all the time for criminal defendants, right? How many times do these jail calls come into evidence in the cases we cover here on Law and Crime, right? Even though the inmates are informed in writing, and even at the beginning of their phone calls, if their calls are recorded, they still make these phone calls, make admissions that can be used against him, or in this particular case, engage in alleged witness tampering. That's going to be a problem for them.
Let me ask you this. You go to victim 1, who we believe in this indictment, in these papers, is Cassandra Ventura. The defense was keen to suggest, look, I know the prosecution is saying that 2016 videotape is evidence of him trying to prevent her from leaving a freak off, that it's evidence of sex trafficking, evidence of his dangerousness. The court also cited these text messages from victim 1 to Sean Combs, where it was the hours and the days following the 2016 attack at the Intercontinental Hotel, where she allegedly writes more. This victim 1 writes him, "I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done." To, again, further evidence of his dangerousness. The defense spent a lot of time to saying, we can show you a different context of this. This is not to support sex trafficking. It's just a toxic relationship. It's a violent, long-term toxic relationship. The judge was not persuaded by that. And I don't know if it's that's not the issue for this bail analysis. Maybe that's for a trial. You talk about her credibility. You try to defend against sex trafficking. This is more about evidence of his propensity for violence. So just to be clear, even if Sean Combs' defense counsel produces all this evidence to say there's a reason he was violent with her, or there's a reason to suggest there was a toxic element to this relationship, that wouldn't be enough to change the court's mind regarding Sean Combs being dangerous, right?
Not at all. And with respect to the video, the defense has said a lot of things that I don't think are true. One is that DHA agents, they intentionally leaked this video to try and taint the jury pool. Well, we know CNN got it from an independent source at the hotel. And they said that the video was edited. But for me, the most telling fact is this with respect to the video. Combs, through his lawyers, denied these allegations for months, approximately 6 months from the time Cassie filed her lawsuit in November 2023, even after the raids, right? The lawyers said this is all extortion, this is all about money, this is a shakedown, none of this happened. But guess what? In May, when that video was released and CNN airs it and we all see it, Diddy comes out and he issues an apology. I don't think it was a very genuine apology, but that's how powerful the video is, Jesse, because people can lie. Defendants, defense attorneys, even prosecutors can lie, but that video doesn't lie. We've all seen it. It shows the propensity for violence. And that's exactly what Subramanian quoted in his order.
What about another potential avenue for Sean Combs to revisit the issue if the conditions at the Metropolitan Detention Center get so bad? We've talked about this before, how the MDC is plagued with violence and health issues. And there was even an example of a judge who refused to sentence a defendant to prison if he knew that the defendant was going to go to the MDC. The reason I bring that up is this is what Judge Subramanian said regarding the MDC. The court also finds that Combs has not shown that a temporary release from detention is warranted. And then he cites a statute. He says, under this provision, a judicial officer may permit the temporary release of the person in the custody of a United States Marshal or other appropriate person to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. Combs' application is based on the conditions at the MDC, which he says make trial preparation impossible. But given Combs' access to counsel and documents, there was an issue with Combs receiving a laptop for the purpose of reviewing discovery. But the court addressed that. The firm deadline for the government's discovery, the end of this year, and the time left before trial over 5 months, Combs has not carried his burden of demonstrating that release from detention is necessary for trial preparation purposes. But the court will promptly address any issue that arises with respect to Combs' trial preparation, and if the circumstances materially change, he may renew his application. Nima, talk to me about that.
Well, Combs is separated from the general population, right? He's with, or was with Sam Bankman-Fried at least, and the irony there is that's someone who was granted bail, tried to tamper with witnesses, so the judge revoked his bail. So that just goes to show how these federal judges feel about witness tampering before trial. Combs obviously has access to the legal pads. I know there was some question of this laptop, and the government has been a little bit slower in extracting this data. We're talking about terabytes of data and getting it to the defense. They promised to have it all done by the end of the year. And of course, Combs will have access to all that subject to the protective order. So to the extent that Combs has access to his lawyers in person, phone, clearly is able to communicate with them with those pads, I don't see how he's treated any differently than any other federal criminal defendant. So I don't think he's going to qualify for release based on changed circumstances, because guess what? And everyone should probably be released from the MDC pending trial.
Well, I guess his argument would be this is such a massive case. It's a complex case. There's so much data, and he might have a target on his back. He's a celebrity. I mean, what would be an example of a changed circumstance that Judge Subramanian would say, home confinement, there's something going on at the MDC, it's too much of a problem? What would something like that look like?
Potentially, if he's attacked in prison and the guards aren't able to keep him safe, maybe that's something the judge would consider. But again, I think he's probably in the safest place he can possibly be. If there are conspiracy theory types that think that, this is another Jeff Epstein type situation where Combs knows information about sex trafficking at the highest levels and he may be killed. And if you really believe that, well, what safer place to be than in federal custody? How safe is it on the outside?
All right, well, let's see what happens. If he loses at the Second Circuit, I don't know if you know this question, can he appeal that to the Supreme Court? I mean, what's his other option? If the Second Circuit says no to him, can he go anywhere else?
You can potentially appeal to the Supreme Court, take a writ. Obviously, the Supreme Court takes very few cases, accepts a very small percentage. I would be shocked if they decided to dive into a bail issue like this. They have bigger fish to fry.
The only thing I could think of, have you ever seen a case like this where somebody has the ability to present such an expansive bail package? In other words, not everybody can afford $50 million bail secured by home equity, private security firm, no phone or internet access. If you could present such an expansive and expensive bail package in your mind that would address every single issue that the prosecution has because of your wealth and your power and your resources, Is that a little bit of an unprecedented issue with Sean Combs? Have you ever seen a private security being used by a defendant like this? Is this a novel issue that maybe could be decided by the Supreme Court? I might be stretching here.
Well, the security issue is novel, but we have seen bail packages like this in complex fraud case. And again, Sam Bankman-Fried, massive bail package, the largest, I believe, at least reported in a federal criminal case. So we have seen it. We have seen some rich defendants out on bond pending trial, and even cases that are more complex than Sean Combs. We're talking about massive frauds and accounting issues, and dozens, sometimes hundreds of witnesses. So I think what Sean Combs, it's unprecedented in terms of the extent of the sex trafficking and the number of victims. We certainly haven't seen that, certainly with someone of his wealth, but I don't think he's any differently situated than these other very high profile criminal cases that we've seen.
All right, so it was definitely a blow to him. It was a blow to his defense counsel, blow to his family, and barring some sort of change of circumstances, it looks like he is going to remain behind bars pending trial, but we'll see what happens. It's always been a shocking case from the very beginning. We'll see. Nima Rahmani, thank you so much for taking the time. Great seeing you.
Thanks for having me, Jesse, as always. And I think one last point, I think this is going to push the case to trial even faster, because I think Combs is not going to want to continue this while he's in custody.
Well, I'm glad you mentioned that real quick, because I was under the belief, I agree with you, that when I think he never thought that he would lose bail. I think he always felt he would make it. And as soon as he found out that he wasn't going to be granted bail, tried to push this trial, as soon as possible, because he doesn't want to be locked up there. But I mean, if you go in and you're rushing to trial, but with you're not fully prepared, either A, he really believes he's going to win this case, no problem, or B, I mean, the other way of looking at it is he's currently locked up potentially till May, his May trial. But if he's found guilty, there's a chance he will never get out. So I'm just curious, why the rush? If really what he's looking at is potentially the rest of his life in prison, shouldn't he take the time to be as prepared as possible?
I'm sure he's going to want to prepare his defense, but if he were out on bond, believe me, he would be taking his sweet time. The lawyers would say,
of course.
Yeah. Yeah. Well, we would probably wouldn't have a trial until 2026 at the earliest. The defense would ask for additional time, say, we can't prepare. There's so much electronic evidence and data. We got to interview dozens, maybe 100 witnesses, people that have come forward, So, and of course, knowing this judge, knowing how deliberate he is, I wouldn't be surprised if he granted those requests. So, yeah, obviously, he's going to want to prepare his defense. But I think that's going to be very different than the Combs defense and the delay strategy that would take place if he were enjoying freedom like the rest of us.
And if you take all those allegations as true for a minute, they were happening since the 90s, the early 2000s, and yet this is really the first time he is potentially going to face accountability. Again, assuming he did all of this. And so you have to ask, why now? Why is this all coming out now? Why is his world falling apart now? The simple answer would be because of Cassandra Ventura, right? She sued him in November of 2023, alleging that she was sexually, physically, psychologically, emotionally abused by Sean Combs for years, that she was essentially forced into sexual slavery and sex trafficked, that she files this massive lawsuit against Combs, and then they settle the next day, the day after it was filed, after all of this was already made public. Do you remember what the statements were that were released? Ventura said, I have decided to resolve this matter amicably on terms that I have some level of control. I want to thank my family, fans, and lawyers for their unwavering support. Combs, he released a statement saying, we have decided to resolve this matter amicably. I wish Cassie and her family all the best. Love. Combs' lawyer, Ben Brafman, released a statement to the Daily Mail saying, just so we're clear, a decision to settle a lawsuit, especially in 2023, is in no way an admission of wrongdoing. Mr. Combs' decision to settle the lawsuit does not in any way undermine the flat-out denial of the claims. He is happy they got to a mutual settlement and wishes Ms. Ventura the best. Now, here's the problem. He settles this after the lawsuit was filed and made public. Everybody saw it. Everybody knew about it. And that led to the beginning of lawsuit after lawsuit after lawsuit being filed against him, accuser after accuser coming after him, and it was because of Cassandra Ventura. And I'll tell you what, I'll give you an example. In a recent lawsuit that was filed by this unidentified Jane Doe, who's being represented by Texas attorney Tony Busby, he's representing dozens upon dozens of alleged victims of Combs. At the beginning of her lawsuit, actually, this is language that's presented in almost all of the lawsuits that were filed by Tony Busby so far, there was a preface that talks about how first Cassandra Ventura filed her lawsuit, then it was filed by Joy Dickerson-Neal, Lisa Gardner, another Jane Doe, Rodney Jones, Crystal McKinney, April Lampros, Adria English, Dawn Richard, and then there's this line. Plaintiff joins many other victims by filing this complaint in hopes their common voice makes it impossible for Combs to assault another person ever again. In other words, if it wasn't for Ventura, would these suits have followed? And it wasn't just civil. The federal sex crimes charges against Combs that he's currently facing, sex trafficking, racketeering conspiracy, transportation to engage in prostitution, those followed too. In fact, in one of the prosecution's filings, they write, in or around November 2023, federal prosecutors from the United States Attorney's Office for the Southern District of New York, working with case agents from the Human Trafficking Squad of the New York Field Office of Homeland Security Investigations, began investigating Combs and others for violations of federal criminal law. November 2023 is when Ventura filed her lawsuit. So what I'm asking is, why didn't Sean Combs just settle with Ventura privately before she filed a lawsuit? Would that have changed his whole life if this lawsuit was never made public? And let's not forget what Ventura's lawyer, Douglas Wigdor, said at the time of the settlement and the lawsuit. As reported by NPR, Wigdor claimed that Combs had offered Ventura 8 figures to silence her to stop the lawsuit from being filed, and she rejected his efforts and decided to give a voice to all women who suffer in silence. And he also added, I am very proud of Miss Ventura for having the strength to go public with her lawsuit. She ought to be commended for doing so. So, should Sean Combs have offered her more? I mean, they did settle the next day. It makes you wonder what was offered. Was the harm already done? I mean, Ventura was able to expose Combs for his alleged wrongdoing, make it public, and seemingly settle terms that were favorable to her. Now, the reason I'm bringing all of this up right now is because you might have seen some recent headlines. You see, Law&Crime has just produced a podcast on Wondery Plus called The Rise and Fall of Diddy. I actually host it, not about self-promotion. I'm not doing that. But what I'm saying is, one of our contributors said, attorney Dante Mills, he said something, and he actually said it in our Prime Crime episode on Combs as well. Dante said that Ventura came to him before she filed the lawsuit and said, I believed I was wronged by you, and she gave him an opportunity to settle the case before she brought the lawsuit. And Dante also said, I know that both Sean Combs' attorneys and Cassie's attorneys were in conversation and talks to see if they can resolve the lawsuit, but they were not able to, and those settlement negotiations fell through. Now, first of all, despite some press on this, I don't believe Dante was saying that he had intimate knowledge of what was happening behind the scenes. He was just giving his take on how these negotiations probably went based on the reporting on this story and his experience. But the fact is, this wasn't settled privately. This became public, and now Sean Combs could be facing the rest of his life in prison. And by the way, as an aside, let me also say real quick, it's not just us here at Law&Crime that have been covering these Diddy stories and updates for you. Websites all over the internet are grabbing readers with headlines like, Puff Daddy stays in jail for trying to influence witnesses. Woman sues Sean Combs for raping her. And that is exactly where a platform like Ground News comes in. So what they are is a small independent team that we actually partner with because they can help us deliver just the facts when we report on stories like this. You can go to ground.news/sidebar to follow along while I show you how it works with this Diddy story. So we get a quick summary of how Diddy's lawyers claim prosecutors allegedly unlawfully obtained his jail cell notes, including attorney-client privileged information. Remember that? Well, based on every source that Ground News found on reporting on this, the left are clearly dominating coverage, making this a potential blind spot for more conservative news consumers. But it's not just about who's covering the story, it's also about how they're covering it. Well, Ground News calculated the majority of these articles come from highly credible sources, so you can instantly see which headlines are more objective and which might be skewing the facts. The bottom line here, don't let someone else's spin shape your understanding of the truth. Just head to ground.news/sidebar or scan the QR code right there and use our link to save 50% off of the top tier Vantage plan, which offers unlimited access. It's the same plan that we've been using. So thank you to Ground News for sponsoring this episode of Sidebar. Okay, let's get back to it. And before I bring in my special guest to talk more about this, just to circle back to what Sean Combs is facing now a year later, he has been accused by federal prosecutors of committing serious and violent crimes, that he abused, threatened, and coerced women and others to fulfill his sexual desires, including participating in sexual performances with sex workers known as freak-offs, that he relied on his power, wealth, businesses, associates to do all this, that he created a criminal enterprise that engaged in all sorts of crimes like sex trafficking, forced labor, kidnapping, bribery, obstruction. So again, could this have all been avoided? With that in mind, let me bring in acclaimed trial attorney Ben Chew, who famously represented Johnny Depp in his very public defamation trial against Amber Heard. Ben, so happy to have you. So good to see you. I mean, you are the perfect person to discuss the idea of the importance of when do you make allegations public? Your thoughts on what I laid out.
Jesse, it's great to be with you again. Yes, I mean, in answering part of your question, I think his life was irrevocably changed by her filing of the lawsuit. And I think he and his counsel should have moved heaven and earth to settle it prior to the actual filing, because once the filing was done, then the Rubicon had been crossed and it just set the table for all of the subsequent lawsuits, civil and criminal, as you point out.
Was it just as simple as he should have paid her more money? Would this lawsuit have never been filed? None of the lawsuits or criminal charges would have come to? I mean, do you think that's what it was? It was an issue of money? Or is it what I said? Look, Cassandra Ventura, she was able to make this lawsuit public. Assuming all those allegations are true, he is now potentially going to be held accountable. His life has been changed forever, and she got a settlement. I mean, she settled on preferable terms. So was it just he didn't offer enough? Or maybe, I'm speculating, was there never really anything he could have done to stop this from happening?
There may be a third alternative. I like your thesis. In my experience, it's not always just about the money.
Right.
In this case, obviously, she felt strongly about what had happened to her, and she had a conscience about what may have happened to others. But I think, and again, we're speculating a bit because we don't know the precise nature of the
Sure.
communications. But were I his counsel at the time, and maybe Bronfman did attempt this, I would have gone to her on what we call the equities and to say, look, you may feel strongly about this. We understand that, but Diddy has a family, and these are people in his family, particularly his children, are innocent of this, and your going public may have implications on them. So my only speculation is that there are other things other than just money that might have induced her or might have dissuaded her from actually filing the case.
Do you think it was also, listen, I won't agree to settle with you, Sean Combs, unless you admit what you did? You know, you have to put out some sort of admission of what happened to me. And that might have been a breaking point in the negotiations, which, by the way, I have to say is really interesting, because even after he settles this suit, he denies all the allegations. He denies every allegation. And then when the 2016 videotape comes out of him beating Cassandra Ventura in a hotel hallway, he comes on Instagram 2 days later and essentially admits that he did that. Now there's a back and forth about, was she trying to escape a freak-off? Was it sex trafficking? Was it a domestic dispute? But he essentially admitted and apologized for what happened on that tape. So it does make me wonder if during those negotiations, one of the reasons they broke off, and maybe one of the reasons he didn't settle this, was because of that caveat.
Yeah, it could be, and that may have been something that she really needed prior to settling it. But if that was going to be his position, then what actually happened was the worst of all possible worlds for him, because he ended up paying the money and the allegations came out. So I think more thought should have been given to you either settle this quietly and do whatever that's required, even if that required a private apology or some kind of other non-monetary compensation, or you fight it. Because again, my experience has been, once there has been one allegation like this, there are going to be others, especially if there is substance to the allegations. They're going to come out of the woodwork.
I mean, it's multiple lawsuits and now federal charges, and it seems, again, all based on her. I'll get to that more in a moment. But look, you also have to remember this is probably not easy for her to come public with these allegations and expose what happened and talk about the pain that she went through. I mean, assuming these allegations are true, it probably was not easy for her to make something like this public, and now she's a spotlight has been put on her, especially if she's a star witness in the criminal case. But look, Ben, you represented Johnny Depp and made his claims public. His personal life was public. His personal life was on full display. Text messages, videos. What goes into a decision like that? I would say for anybody, but particularly a public figure, that can't be easy. The risk of making things like that public versus the payoff.
Yeah, in his case, these allegations, the false allegations of domestic abuse had already been aired in 2016, in the context of the divorce. So some of these allegations were already out. In that case also, we were confident, and he certainly knew with a metaphysical certitude, that the allegations of abuse were false. So there wasn't the concern about other people coming out of the woodwork. As we said in our closing argument, this is the Me Too case without any other Me Too's, because there were no other women who had ever made this allegations against him. So in that case, yes, it was a decision because he knew that there would be embarrassing texts and other things coming out. But he knew that he was innocent, and even though he was assuming the burden of proof in a defamation case. So we had to prove, the negative, which is always hard. We didn't have the concern that there was anything else out there.
But it's not easy, right? It's just not easy fighting this publicly, right?
No, it's not. And there were certainly down moments, and there was a lot of unfair, negative publicity.
Right.
Journalists who I had hitherto respected never changed their tune despite the actual evidence that came out. So that is, we anticipated some of it, but we didn't anticipate all of it.
It makes you wonder, again, how difficult it might have been for Cassandra Ventura to do this, and also for her lawyers to have that conversation with her, again, assuming these allegations are true.
Well, and not to interrupt, Jesse, but you make a really good point. And again, I'm speculating, but perhaps Diddy and his counsel thought it was a bluff. In other words, knowing how difficult it would be for Cassie or any other woman or man, for that matter, who'd been a victim of abuse to come forward, it's possible that he believed that she wouldn't actually do it because they had a long relationship. I'm assuming, and again, this is assumption, that the power dynamic was he was usually in charge, and maybe he felt, as powerful as he was, that she wasn't going to do it.
And that's a really, really good point. It goes back to the idea of why now? Why is this happening now? And if you take the allegations from prosecutors and you take as true, and you take the allegations from the multiple people who've sued him as true, he always found a way to cover it up. He always found a way to pressure people to not come forward. I am curious, though, do you believe that if Cassandra Ventura never filed her lawsuit, do you still think that this would have happened? We'd be in the place that we are today because, look, she filed her lawsuit right before the expiration of the New York Adult Survivors Act in New York. It was set to expire November 24th, 2023. Excuse me. This gave a one-year look-back window to file these kinds of lawsuits for sexual abuse that would have otherwise been too old. They would have been time-barred by the statute of limitations, but she was not the only one. After she filed that, other people filed those lawsuits against him under the same statute. So it makes me wonder, would they have come forward if it wasn't for Cassandra Ventura? It's difficult to say, but again, we go back to the main question, Ben. If she never filed her lawsuit, or if he settled with her privately before all of this is exposed, do you think we would be where we are today?
Maybe not. I mean, once the Rubicon is crossed, once Cassie had the courage to file that complaint, it made it a lot easier for lawyers and alleged victims to come forward. Being the first is always, as you know, the most difficult. And so it may well be that if he had settled privately or she hadn't filed it, that he wouldn't be in the situation he is now.
And it seems, based on what I mentioned about the prosecutors, it was because of this lawsuit and the other ones that they started investigating.
Absolutely.
And you
She
know what's
did a lot
interesting?
of the spade work for the criminal investigators.
And what's interesting is, according to prosecutors, Combs seemed to know that the floodgates would open for him, because in this filing from the government, in one of their filings, they write, specifically, following the November 2023 lawsuit, again, Cassandra Ventura, the defendant and intermediaries acting on his behalf reached out to potential victims and witnesses to the alleged conduct, including individuals he did not speak to regularly and had not spoken to in years, to attempt to feed those victims and witnesses false narratives about the defendant's criminal conduct. For example, on or about November 19th, 2023, just 3 days after the filing of the lawsuit described above, the defendant made multiple calls to another victim of his sexual abuse and recorded certain of those calls using the cell phone of a co-conspirator. During the calls, the defendant repeatedly asked for the victim's support and friendship and attempted to convince the victim that she had willingly engaged in acts constituting sexual abuse. The defendant also assured the victim that if she needed the defendant to, she ain't got worry about nothing else, a thinly veiled attempt to coerce the victim into adopting and supporting the defendant's false version of events to protect the defendant. Now, assuming that's true, Ben, he knew that the floodgates would open, and maybe like one day after the lawsuit was filed and he settled, he said, uh-oh, this could start everything. I got to jump in there. I mean, again, assuming these allegations are true.
Yeah, and that might support the theory that he thought it was a bluff, and once he saw the ramifications of it, he sprang into action. But that also was a mistake, because he went from having civil difficulties to criminal problems, which obviously put his liberty at stake, and now he's lost his liberty.
You know, Ben, going back to Cassandra Ventura, she seems to be the star witness in the prosecution's case, because we believe she is victim one in the prosecution's filings. This person hasn't been identified, but based on the descriptions surrounding victim one, it's consistent with Cassandra Ventura's claims. Don't know for sure, but Judge Subramanian, who's the judge overseeing this case, ordered that he listed in his order, where he just denied Sean Combs bail, he lists out text messages between Combs and victim one, and writes that this was just hours and days after the 2016 attack by Combs on Ventura that was captured on surveillance footage and was published by CNN months ago. And this, by the way, happened at the Intercontinental Hotel, I believe in Los Angeles. And it says that victim one, again, who we think is Ventura, allegedly wrote Combs, "I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising." Christian Combs, Sean Combs' son, was served with legal paperwork at his father's Miami mansion. And you know, that was the property that was raided by federal authorities earlier this year, before Sean Combs was arrested on sex trafficking, racketeering, and prostitution charges. By the way, that Miami mansion seemed to be the same property by which Sean Combs' legal team was saying, that's where we're proposing Sean Combs stay on home confinement if he's granted bail. Now, the current judge overseeing this case, Judge Arun Subramanian, said no, Miami's not going to work. If he's going to do home confinement, has to be in New York. But it doesn't really matter, because at the end of the day, Judge Subramanian denied Sean Combs bail. That was the third time that Sean Combs had actually been denied bail in total. Now, going back to this legal paperwork that Christian Combs was served, according to In Touch, this came from Grace O'Markey. This is somebody we've spoken about before here on Sidebar. She was the one who filed a lawsuit against Christian earlier this year. And we remember that O'Markey's civil lawsuit accuses Christian of assault, battery, sexual assault, intentional infliction of emotional distress for an alleged incident that happened on Sean Combs' yacht back in 2022. And I'm going to talk about the timing of the service of these papers in a second, but first I want to recap this lawsuit for you. So according to the civil complaint, O'Markey, 25 years old at the time this happened, or allegedly happened, says that she was working as a steward on the yacht that Sean Combs had rented or chartered, and she was in charge of providing food and drinks for a 12-hour period. And she actually said that she believes the alcohol on that yacht had been laced with drugs, because she says that women would have one drink and then almost immediately pass out or start falling over. And again, that is very consistent with allegations that have been made before against Sean Combs. In fact, she described what she thought would be a wholesome family excursion to what she describes as a hedonistic environment. Now, going back to Christian Combs, O'Markey says that Christian, he'd been staying at a villa on the shore, but then he would come onto the yacht in the evenings to party and have a good time. And now we focus on December 28th, 2022. She says that Christian reportedly arrives on that yacht very intoxicated and then pressures her to take shots of tequila. She says that she did, that Christian allegedly tried to get her to drink more, and she tried to get her to drink more in the yacht's makeshift recording studio. And that's important, and I'll explain why in a second. The complaint reads, at this point, defendant C. Combs violently grabbed plaintiff's arm and began hurting her. He pulled plaintiff to the seat beside him and prevented her from getting up. And she says from there, she claims from there, that Christian allegedly kisses her neck and face as he gropes her legs, her breasts, her private areas. And according to her, she reportedly tells Christian, quote, excuse me, you don't touch my legs like that. I'll move my legs where I want to. If I want to do this, then I will. You don't touch my legs like that. Now, remember where I said this was happening, this recording studio? Well, the alleged assault was reportedly witnessed by Rodney Little Rod Jones. This is a music producer who had apparently accompanied Combs basically everywhere for a year while they were working on Combs' latest album, Love, Off the Grid. And we remember that Rodney Jones has filed his own separate lawsuit against Sean Combs and others. And he was saying that he was in this recording studio when this was going on, when Christian and O'Markey were there. And he might even have some audio that was recorded of this interaction. And as I said at the time when we first broke down this lawsuit, that is key evidence if they really have that. Now, O'Markey says this is what happened next. She says she tried to go back to work, but Christian ends up finding her and wants her to find him a place to sleep for the night in the yacht. So she takes him to the cinema room of the yacht. And that is when she claims Christian stopped her from leaving, groped her, took off all of his clothes, and tried to force her to perform oral sex on him. Now, she says she was allegedly able to fight him off. Someone walks into the room, and then she was able to leave. And she said when she reported this to the captain, according to her, the captain berates her. And she alleges that the captain may have even been paid off by Sean Combs to keep quiet about what happened. And I will tell you what's really interesting about this complaint, embedded in the complaint are photographs that purport to be O'Markey's arms with bruises on them. And that is really interesting. You don't usually see that in a complaint like this. Now, she's not only suing Christian Combs, like I mentioned before, for all those different causes of action, but she is also suing Sean Combs too. You see, Sean Combs is named as a defendant because she accuses him of aiding and abetting Christian's behavior, as well as having premises liability because he was the leaseholder of the yacht. Premises liability means that you have a duty to keep people on your property safe from injuries, so she's seeking unspecified damages in this suit against both of them. All right, so I want to bring on right now criminal defense attorney Mauricio Padilla, friend of the show. He's represented some very high-profile defendants in high-profile cases. Good to see you once again. So I don't think we've had a chance to talk about this lawsuit, and now that the news is reporting that Christian has been served with papers here, why is that significant?
Well, it's significant because anytime that they have the opportunity to continue to remind the public of the malfeasance of Diddy, of Diddy's son, of anything related to sexually inappropriate behavior, sexual assault, it helps. It helps the government continue to, lay out the narrative of how bad Diddy was, how bad Diddy's son was. So I think it's consistent with, what they've been doing, putting it out there and really destroying his character. I'm not saying that he didn't do anything to deserve it. I'm saying it's consistent with what they're doing, whether it's the government or the lawyers that are suing him civilly.
Sure. I think I meant more in terms of the service of the papers. Serving of the papers, that's a requirement in a litigation, right? So now this is a real
Yes.
moment where he has to respond. This is not just a filing. This is the next step once he's actually served papers. And he's served, by the way, as I mentioned, at his father's Miami mansion. That's what's being reported.
Right. Right. So when there's a civil suit filed, then it's filed, and then eventually you're right. Then it has to be served, and there's certain requirements, and after you get served, you have a certain number of days to respond. I can't remember the last time that a defendant being served even made the news, which goes to show the type of case that this is. It's not newsworthy that he got served, but this is the only case that I've seen that. But this case continues to come back, and it seems like if the public isn't getting tired of it. So it's rare to see that even the service makes the news.
I got to tell you, one of the things that's interesting about this is I couldn't tell at first, was this new news? Because we talked about her filing this complaint against him, this lawsuit against him months ago, I believe in April. But now we look at the docket and it says that on November 19th, 2024, there was proof of service by posting. This was filed by Grace O'Markey. And also on November 19th, 2024, it says proof of service by posting filed by Grace O'Markey as to Christian Combs, the defendant. And then it talks about the service costs, and it talks about the mailing date. The mailing date was apparently October 23rd, 2024. So what's interesting about that is, and again, if I'm reading it correctly, isn't that a long period of time between filing and proof of service? Unless I'm missing something.
It is, but there are situations where people could be evading service. You can't find them, and what you really want is personal service. And posting basically means that they literally did that. They posted the lawsuit, and there's some states that allow for posting. There's some states that allow for substitute service, and there's some states that allow for posting only after you've made certain requisite attempts. So it's very possible that they had been trying to personally serve them, they gave up, and then they went ahead and posted it. It is rare to see that many months pass, but you have multiple defendants in this case, and I believe that they filed it. It was in the media. They're working on it, so it isn't completely that rare to see this many months pass. When you're dealing with celebrity clients, you're dealing with clients that have a layer of security that prohibits you from actually serving them like you would a regular person.
And by the way, I can't confirm this in any way. If there was difficulty in serving him because of something Christian Combs did, right? And I want to be very clear. I'm just assuming, I'm making the allegation. I'm not saying he did this, but if he created a difficulty in service, typically speaking, whether it's him or any defendant in a civil case, does that hurt them? Does that hurt them in the case?
Well, I mean, hurt them in the sense that, yeah, I mean, anytime that it looks like you're evading service, it hurts how the public views you, because it feels like if you're not, facing up to the lawsuit, and in the eyes of the judge, they can look and be like, this guy's, in the affidavit for the process server, it will detail the attempts to serve and what occurred. So if you have someone that's fighting with a process server, not opening the door, which is situations that I've had in my career, yeah, that goes in an affidavit. And when the judge reads it, the judge already knows that you're not acting professionally, you're not dealing with things the way that you should. So yeah, it could hurt, but it shouldn't affect a judge's decision in the case. But as we all know, anything can affect the way a judge views you.
Right. And again, I want to make this abundantly clear. I'm not saying he did that in any way. I'm not saying he made it difficult to serve the papers. It's just, if I'm looking at the docket, I'm thinking when the lawsuit was filed, that time difference is something that's interesting. So now I want to ask you about the case. I want to ask you about her lawsuit. I mentioned it before. I described it before. What stands out to you? Do you think it's a strong case against Christian Combs?
I think it is a strong case because you have witnesses. You have an audio recording of him actually telling her to take shots, and they put the transcription of what is in the audio, and then it goes in conjunction with this criminal indictment of his father and the similarities. So it's not just the isolated allegations that Diddy's son did this. It's in conjunction with he's sitting in a jail cell charged with all these other crimes. So I think it is a strong case, and what it shows, what the complaint is illustrating, is this completely out of control party on a super yacht, including various celebrities. That when you read it, it kind of rings true. I mean, when you read it, it doesn't come off as being something that's completely unbelievable. You have to take into consideration that someone like Diddy, that's been living this type of lifestyle for a long time, and then you have his 25-year-old son that maybe just acting like a 25-year-old, but a 25-year-old that's had no control in his life, that doesn't know what boundaries are, or what the appropriate parameters between a man and a woman are. Because when you read it, the way it describes he was acting is completely inappropriate, and there's going to be a lot of witnesses, people that worked on that yacht. That we're talking about, I don't know how many 20, 30 crew members. I don't know how many people are on a super yacht, but there's plenty of witnesses and audio recordings, and I think it is a strong case against his son.
Look, and what you said, these are allegations against Christian Combs. We don't know the full story. We don't know if these are true. Right. I will tell you, I thought was interesting, embedded in the complaint were these pictures of what appear to be, or what is purported to be, Omarke's arms with what appear to be bruises on them. And I'm curious what you made of that. Is it typical to include that in a complaint, to include actual photos of the alleged abuse?
I was going to mention that because I haven't seen it, and I haven't seen it in the actual complaint. I've seen it like exhibit attached to the end of the complaint. They just put it straight in the complaint in picture format. And I think if I had to guess, it's just because of the high profile nature of this case and the fact that the plaintiff's lawyers know that the complaint itself is news. So that complaint is going to get circulated. And you know what? We're going to make it easy for you. We're going to give you the pictures. We're going to spoon feed you the evidence in the complaint to make it easier for the viewing public, which is consistent with they're kind of proving their case in the media before it even gets to the courtroom by way of pictures. And
do you think the case against Sean Combs, the fact that she's suing him for premises liability, it was his yacht, he had a duty to protect. Do you think that's a strong claim?
I think it is, and it's not rare to include that cause of action. At the end of the day, it was Sean Combs that put this all together. No one's saying that his son was the one that hired the super yacht. It was him. Like, he threw this event. When you throw an event of this magnitude, because it's a huge event, including a super yacht, you're under the obligation to have security, to have everything, unless you contractually gave that to the super yacht itself. It's your event. You're under the obligation to protect the people that you invite, the invitees. And apparently, from when you read it, he obviously did not. He put into place this event with alcohol, with alleged drugs, with allegedly people getting drugged. So ultimately, you're responsible if you do plan and throw an event like that.
I said it was new, but really, this is an issue that has come up before. You see, Sean Combs' defense lawyers, they have argued that the conditions at the MDC make it incredibly difficult for him to properly review evidence in the case and prepare for trial. And yes, he has a constitutional right to prepare for his trial. But they have been arguing for quite some time that because of the incredible amount of material in this case, you really can't do it without a laptop. He needs a laptop to review everything. I mean, this is a massive case. Combs is accused of sex trafficking, racketeering conspiracy, transportation to engage in prostitution, and they are looking at him allegedly operating a criminal enterprise from 2008 to 2024. That is a long, long time period. And when he was first arrested, prosecutors at the time, they said they interviewed more than 50 victims and witnesses. They obtained over 90 cell phones, laptops, over 30 electronic and storage devices, firearms, physical evidence, records that were obtained pursuant to over 300 grand jury subpoenas and voluntary production. Think about how much stuff there is. So it is a massive case with a lot of evidence. And in fact, this was an issue that Combs' team had raised when trying to get him bail. They argued, look, he can't review all of this material in the MDC, so he needs to be released on home confinement immediately. Unfortunately for Sean Combs, that argument was rejected by the judge overseeing this case, Judge Arun Subramanian. In fact, in Judge Subramanian's order denying Sean Combs' bail, pretrial release, he wrote, given Combs access to counsel and documents, there was an issue with Combs receiving a laptop for the purposes of reviewing discovery, but the court addressed that. The firm deadline for the government's discovery, the end of the year, and the time left before trial, over 5 months, Combs has not carried his burden of demonstrating that release from detention is necessary for trial preparation purposes. And with respect to that laptop, the prosecutors in a pretrial hearing actually addressed that. Prosecutor Christina reportedly told the judge that Combs will be provided a laptop at the MDC and it will be preloaded with information that he is allowed to have and see. So with all of that in mind, now we want to get into the defense's letter that was just filed this week. And they write Judge Subramanian saying the following, quote, "We write on behalf of Mr. Combs to request that the court direct the MDC to provide Mr. Combs with the laptop prepared for him by the government and allow him to use that laptop on his unit consistent with the way other inmates on his unit are permitted to use their laptops." 2 months after he was charged and detained on November 25th, 2024, the government provided the MDC with a laptop that Mr. Combs can use to review discovery, take notes related to his case, and otherwise assist in his defense. In the 9 days since then, Mr. Combs has still not been provided with the laptop despite numerous inquiries by defense counsel. And Combs' lawyers doubled down because they say this morning, and this was filed on December 4th, by the way, they say this morning the government gave them only two options. One, Sean Combs will only be provided with the laptop in the unit's video conference room during select times when legal staff is available and when that room is not otherwise being used during other inmates' legal calls. Or two, he will only be provided with the laptop in the legal visiting room between the hours of 8 and 3:30 p.m., but not both. So not both. Now, Sean Combs' lawyers objected to this. They say these restrictions are, quote, untenable, they're unjustified, and they argue it seems to only be placed on Combs, that these restrictions were not placed on other inmates in his unit or on his unit. And they say the problem is this limits the amount of time he has to use the laptop because he's going to either be forced to choose between using the laptop or meeting with his attorneys. He only has limited time. And Combs' lawyers say essentially if this is about security or privacy issues with what he's viewing, the material doesn't contain any evidence designated as attorney's possession only, meaning that it should only be disclosed to attorneys in this case. The defense is arguing that this won't endanger the safety or privacy of any alleged victims or witnesses in the case, and they say there's no reason to believe Combs is going to show this stuff to other inmates. And then they write this: moreover, given the government's efforts to surreptitiously monitor and record his handwritten legal notes, Mr. Combs' need for a laptop to take legal notes free from government surveillance is heightened. Now, that is in reference to what happened a few weeks ago when the defense accused the government of possibly violating Sean Combs' rights by having in their possession photographs of paperwork in Combs' jail cell that they say might have been privileged writings. That is a whole separate issue that Judge Subramanian has been working through to see whether or not privileged material was improperly photographed and handed over to the prosecution. But even so, they brought it up again here as a little kind of sting to the prosecution. But in the same vein, the defense also writes in the letter, in addition, last night, defense counsel learned that the MDC has been providing the prosecution team, and not via the filter team, copies of MDC attorney visitation forms. By the way, a filter team is kind of this independent group of examiners who take evidence, take documents and materials, and they literally filter out what could be privileged and that shouldn't be disclosed to the other side. An example is attorney-client communications. So the defense writes, who Mr. Combs meets with in connection with his legal defense, including potential experts and investigators, is potentially privileged. Even if not privileged, this level of surveillance offends due process and hampers his ability to prepare his defense. So with all that being said, the defense is asking the court now to step in. And they are asking the court to order the MDC, the Metropolitan Detention Center, to provide Sean Combs this laptop and to allow him to use it in his jail unit. And to also stop sending these attorney visitation forms to the government, to the prosecutors. Well, as you can imagine, not surprisingly, the prosecution responded. And they argue that what the defense is asking for is premature and moot. They write, pretrial defendants housed at MDC review discovery during designated hours using computers within their housing units. In exceptional cases, particularly those with especially voluminous discovery, courts in this district have permitted certain pretrial defendants to access laptops preloaded by the government with discovery materials so that those defendants can prepare for trial while in custody. And the prosecutors cite other cases to support that. And they say, look, the MDC informed us that out of approximately 25 other inmates in the defendant's unit, in Sean Combs' unit. Only 3 other inmates are actually allowed to use laptops. So in other words, Combs, he is in a unique position. He is being granted kind of an advantage here in a way. But the government cautions, look, even if he's being provided a laptop, normally a general rule of practice is that comes with limitations. That comes with restrictions, like how long an inmate can use the laptop and where they can use it, and not to copy or transfer material to other people. To support that, the prosecutors cite a case where a defendant was allowed access to discovery materials on a laptop, but Monday through Friday in the MDC visiting room for 10 to 15 hours per week. So there were limitations put there. Now here, prosecutors say, look, we agreed to give Sean Combs a laptop. We started producing evidence for him to review on there. But the majority of the documents on there, they're sealed, meaning the defendant can see it and he can review it, but only when he's in the presence of Bureau of Prison personnel or law enforcement personnel or his defense attorneys. And they say, according to the MDC, and remember, prosecutors are deferring to the MDC a lot here. They're the ones who have the responsibility of housing Sean Combs and ensuring security and privacy and any kind of those issues. But they say, look, according to the MDC, Combs could use the laptop in the unit's visiting room or in the video conference room. But again, in both choices, there are certain hours he can use it. It has to be within a certain time frame. And also, it can't be within the presence of other inmates. Now, there was a third option for him to use it in his own unit from 8 a.m. to 3:30 p.m., even if there are other inmates around. The prosecutor said that doesn't work here because these are sensitive, sealed materials talking about the names of alleged victims and witnesses and travel, financial records of other people. And this would violate the protective order that has been put in place by Judge Subramanian, which protects against certain information from being disclosed to third parties. So it's just too much of a risk. So prosecutors say, look, he's got these 2 options. These are 2 viable options. And they also say, look, in response to Sean Combs' lawyer's argument, well, this puts an unreasonable time limit on how he can review the material. They say, tell you what, let's see how this goes. If there is a problem, we can address it at another time. If he is being split between time to see his defense attorneys and review this laptop, then we'll come back and review this. But what the defense is asking for now, for the court to step in, they argue, prosecutors argue, it's just premature. We are doing 2 things simultaneously. We're giving him access to review evidence in this case, and we are also protecting the material from being disclosed. And also, in response to the defense's argument that the MDC stopped sending prosecutors the attorney visitation forms, the government argues, first, these forms simply say that an attorney visited his client. That's not privileged. Number 2, Sean Combs can't complain about us reviewing these visitor logs or these visitation forms because it was he who made access to his attorneys an issue in this case when he was arguing for bail. Namely, that when there was that sweep for contraband at the MDC, remember we talked about that? There was that pre-planned sweep at this facility looking for all sorts of illicit materials like the homemade weapons, and there was electronic devices. Well, remember, Sean Combs' defense counsel had argued at the time, and this is what's brought up by prosecutors now. They said, look, this sweep delayed in us being able to meet with our client. We lost time in trial preparation. In other words, prosecutors saying, you're the ones who brought up this issue of meeting with your client, access to your client. So now these visitation logs are important. They're important in us addressing that. And number 3, they say this argument about that they shouldn't be entitled to having the visitation forms. They say, look, we don't plan on collecting any of these forms unless Sean Combs continues making it an issue of how often he meets with his attorneys. Oh, and by the way, they also talk about one more thing in their letter. They completely reject Sean Combs' argument that, look, he needs the laptop to take notes about his case. Prosecutors say, no. That goes beyond the intended purpose here. To allow him to do that, they say, would create unjustified disparities between Combs and other defendants who don't get that treatment. He can't use this laptop just to take notes. That's not fair. So that was the prosecution's response to the defense. But now we have a follow-up response from the defense, and the battle of the laptop and visitation continues. So in their subsequent letter to Judge Subramanian, Combs' lawyers say, quote, first, contrary to the government's argument, Mr. Combs' reasonable request for laptop access is consistent with the way other inmates in his unit access their laptops. Other inmates are permitted to use their laptops in the unit, notwithstanding the fact that their laptops also contain sealed material subject to protective orders. There is no reason to treat Mr. Combs differently. And they cite cases in support of that, although I'll tell you what's interesting. By the way, a little legal primer here. In legal letters like this, correspondent briefs, complaints, anything, when you cite a case, you cite the case, the name of it, you cite the citation where it can be found, some of the details like the court, the year, and then in parentheses, there's a brief snippet that you're quoting about, whether it's a specific quote or the holding of the case, the main point that you want to say, why is this case relevant? I thought it was interesting here that in the brief description of each case that they cite, it doesn't say anything about using a laptop in a private unit or about sensitive materials per se. It's just about how defendants were able to more liberally use laptops. Just thought that was interesting. Anyway, next, Sean Combs' lawyers say that it is absurd that prosecutors are saying Combs can't take notes on the laptop because he could take notes on the discovery on the laptop, and taking notes on discovery on the laptop is the same thing as taking legal notes about the case, that he should be able to do that on the laptop. And they follow up and double down, saying that he has a right, especially since his legal notes, they alleged, were improperly photographed. That's the issue that I talked about before. And they argue if he has to keep taking handwritten notes, it, quote, subjects them to further surveillance by the government, and that is unjustified. But they also say Sean Combs is being treated differently. They argue that that would be, quote, inconsistent with how other inmates in his unit have been using laptops to create and share work product in their cases with their lawyers. And you know who Combs' lawyers actually cite in support of that? Sam Bankman-Fried. Remember him, the crypto fraudster? They argue that in that case, there was a laptop, and it was said that that laptop would enable him, presumably the defendant, to review materials and share work product with counsel through the exchange of hard drives. And Sean Combs' lawyers say, look, if they don't get what they're asking for in the end right here, then this would infringe on Combs' constitutional rights. More specifically, it seems they're talking about his due process rights and his right to assistance of counsel in a case. So there you have it, little tangential update in the case, little side issue. I don't know. I find even minor battles interesting, even if it's about a laptop, interesting to see the back and forth between Sean Combs' defense counsel and prosecutors. Kind of gives us a preview of maybe what a trial will end up looking like. But there you have it. We'll keep on following any updates for you in the case. Thank you so much for joining us here on Sidebar. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.